Good afternoon, everybody. My name is Kevin McConnell, Captain of the Lloyd Fire Department. I'm here today to give testimony and arguments on our arson investigation, evidence seized for a fire at 614 Main Street. At 1:17 p.m., our units responded to 614 Main Street for a reported structure fire. Upon arrival, units found the property secured and nobody at home with a working structure fire. Units forced entry to the home, extinguished the fire, and notified arson of an investigation that needed to be done. Upon picking up equipment and getting ready to return to quarters, our units responded to another fire with reported children trapped. This left the home unsecured with the family on the scene. Our arson investigator was not on scene at the time of the departure of units. He was en route. Upon arrival, the investigator found the family had left the property. The home was unsecured, and nobody was on the property from the family, the homeowners. Entry was made to the unsecured home so the investigation of the fire could occur. The investigation began in the exterior with pictures and collection of evidence. The investigation made its way interior. This is in compliance with the Mass General Laws, Chapter 148, Section 2, which states the head of a fire department, wherein a fire and explosion has damaged property, shall investigate the cause. Upon investigation, evidence of arson was found by the investigator to include a pour pattern and melted plastic behind the television. Many valuables have been removed from the home, and the living room was staged to appear as if it was occupied with property. Entry to the residence can fall under the extingent circumstances, which allows for emergency entry to extinguish a fire, which our units did. The arson investigator was not on the property at the time of the fire. The property was never officially turned back over to the property owners, and therefore was still under the control of the local fire department within reasonable time. There was a few minutes between leaving to respond to another emergency and the arrival of the arson investigator, which does constitute reasonable time for re-entry to the property. This also falls under a state Supreme Court ruling in Connecticut, which a 6-1 ruling was held up, that police investigators were allowed to remove evidence without a warrant in the case of Christopher Bernier. The case from 1994 stated that arson investigators were allowed to remove charred floorboards and test them for arson without a search warrant. In another case, Bennett versus the Commonwealth of Virginia, the courts ruled that evidence obtained without a search warrant was legal because the fire marshal's daytime entry without force under the authority of the statute was such permissible inspection as was contemplated by Camara and does not violate the Fourth Amendment rights of the defendant. Therefore, we, the city, feel the evidence of arson here is present. The need for a search warrant was not there, and the evidence should be allowed into court as it was not illegally seized. Thank you.